I do have skills that make me a nightmare for people like you.
Ladies and gentlemen, boys and girls. Well, this is part 2 of the Waitemata Community Law Centre subject matter jurisdiction and prosecutorial misconduct subject. You've no doubt in part 1 listened to Robert and my's conversation in regards to subject matter jurisdiction, the fact that the prosecution has to establish that. And well, you can say in theory, because they never do, but it is part of the prosecutorial misconduct not to, or possible prosecutorial misconduct. Now, you might ask, why do I ask these questions if I think I already know the answers? Well, it's real simple. I can think whatever I like, but unless, and through my own research, I come to these conclusions. But I'm actually asking for legal clarification. I'm asking a legally trained person, or man or woman, to interpret the legalese for me into English, because I might think I know the answer, but I need to know if that can be verified one way or the other. So that's the reason I ask questions that I already know the answers to. So anyway, so what Robert did was he replied to me on the 28th of August, first off, saying, hi, I asked one of our senior lawyers about jurisdiction of the police and jurisdiction of the district court and its judges. In New Zealand, the police are governed by the Policing Act 2008. Tell me something I don't know. Police refer to Section 3 and Section 9C. Number 3 is purpose. The purpose of this act is to provide for policing services in New Zealand and to state the functions and provide for the governance and administration of New Zealand police. Pretty straightforward. It's there to tell the police how they're supposed to conduct themselves. 9. Functions of police. The functions of the police include A. Keeping the peace, B. Maintaining public safety, and C. Law enforcement. District court jurisdiction is outlined in Section 9, subsection 1 of the Criminal Procedure Act 2011. Section 9 states jurisdiction of the district court to conduct criminal proceedings. And don't forget, a traffic infringement is a criminal proceedings. It's not civil. They need to make it criminal. If it's civil, then it's just a simple dispute between two parties, but they need to make it criminal so they can put you into that jurisdictional box and treat you accordingly. Even though there's no victim 90% of the time, no one is hurt through a speeding ticket. District Court judges' powers are outlined by Section 19 of the District Courts Act 2016. Section 9 of the District Court of the Criminal Procedure Act 2011 is 1. Subject to subsections 2 and 3 and sections 114 subsection 2, the District Court has jurisdiction to deal with a proceeding for any offence. Okay, so now they are offences and not crimes. District Court judge powers are outlined by Section 19 of the District Courts Act 2016. 19. Powers of a judge. 1. A judge has the power A. to exercise the civil and criminal jurisdictions of the court in accordance with his or her own warrant of appointment, and that's it. Doesn't tell me anything else. So, dandy. He sent me cut and pasted sections out of different legislative acts which I'm not legally trained to interpret. That's why I'm asking them to do. But of course, they're not there to help you. Their first duty is to the court. So I respond back to Robert, or actually I respond back just to info@Waitemata Law Centre. Hi there, after speaking with Robert from your establishment, I had asked him whether I had the right to make a fully informed and voluntary plea, and whether the prosecutor had to supply evidence to the court of subject matter jurisdiction prior to a plea being entered. For some reason, Robert has sent me the above sections of legislature, which I do not understand as I am not legally trained to interpret. Judge Tim Black, who threatened, demeaned and intimidated myself on the 13th of July 2017 at Auckland District Court, Courtroom 2, who now has a JCC complaint lodged against him for his actions, failed to clarify whether this had been satisfied. He ignored my intent, wish and direction to make a fully informed plea, and while standing there holding up an unsigned plea of guilty, which I was happy to sign should clarification be satisfied, and then submit to the court, he deemed a not guilty plea on my behalf, practising law from the bench. He stated that I was in New Zealand, the laws of New Zealand apply to me, however he stated this was a presumption. Surely, as I am presumed innocent of all elements of any charge or allegation, subject matter jurisdiction must be established. If I was a foreign diplomat or an active service member, the court would not have subject matter jurisdiction to preside. I have sent a number of correspondence to New Zealand Police asking for clarification and had zero response. I have questioned this information to be informed as to make a fully informed and voluntary plea, and was threatened with contempt and detainment. Note that all was captured on video and audio, even though the registry sought direction from Tim to have my recording equipment confiscated for security, which surrounded me in Courtroom 2 at Auckland District Court. Pity they missed a couple of recorders for them. Although I can appreciate the information supplied, this does not answer my questions. Please clarify the following. 1. Do I have the right to keep an independent record of these proceedings given the inaccuracies of the court transcript? 2. Can the court accept an uninformed and involuntary plea entered on behalf of the defendant against the wishes and intent of the defendant? 3. Can the judge enter a plea against our wishes, intent and direction? Four, is it prosecutorial misconduct not to establish subject matter jurisdiction in relation to a matter? 5. Robert seemed to comprehend my questions at the time, however, I have not asked about the powers or function of New Zealand Police, nor have I asked about the court's jurisdiction. I am requiring evidence to support New Zealand Police's claim, which to date has not been established. Do you comprehend this? 6. How do I have the plea entered by Tim Black removed, as this was against my wishes? Lastly, I would like to arrange a time to talk to a legal advisor for clarification. Please call me on either blah 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 or blah 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 to make this arrangement. The closest to me would be Henderson area. Should you wish to see Tim Black's despicable behaviour, you can watch it on YouTube. Here are the links to date, and I supply them all 10 links. Every single piece of correspondence with relation to this matter has been published in accordance with rights exercised and expressed within the New Zealand Bill of Rights Act 1990 Section 14, which the Auckland District Court appear to not give two hoots about. Warm regards, me. I got a response back from Robert. Dear Mark, thank you for your emails. A. Regarding the 6 points of your inquiry of earlier today, I have spoken to one of the senior lawyers at Waitemata Community Law Centre, and their advice is as follows. 1. There is a presumption that a defendant may take written, pen and paper, rather than digital, notes of court proceedings. However, permission from the bench must be sought to make verbatim recordings in any form of court proceedings. I'd like to say that he hasn't actually backed that up with anything to show me that. It's nothing in legislation saying this. It's a presumption. Whereas I'm actually giving notice of what isn't presumed. It's been expressed. There is no longer an implication or anything implied once you have expressed to the contrary. I've expressed and written notice to the court numerous times that I wish to exercise my rights that are already affirmed in legislation, which means to record, receive, impart, and seek information and opinions, which is exactly what I'm doing, in any form of any kind. That pretty much clears it up to I can record it however I wish. I can seek, I can receive, I can impart however I like. Moving on. 2. Court ought not accept an involuntary plea entered on behalf of the defendant against the wishes and intent of the defendant. However, it must be formally brought to the court's attention that the defendant does not enter such a plea. Did that on the day, got threatened. Unless a judge can show justifiable cause, which there isn't any, a judge ought not enter a plea against the defendant's wishes, intent and direction. Hope you're listening to that, Tim. 4. It is possibly prosecutorial misconduct to not establish subject matter jurisdiction in relation to a matter. 5. If the New Zealand Police have not made full disclosure of evidence to support New Zealand Police's claim to a defendant or their legal representative, it will be necessary to approach New Zealand Police and request that they disclose such evidence. And I did that again on the 3rd of October, one day after receiving this email on the 2nd. And number 6, in order to have a plea changed, it must be formally brought to the court's attention that the defendant wishes to change a plea. Slight bit there. I want it struck. I'm not wanting to change it. There's no plea being entered because I haven't been fully informed of the nature and cause of these proceedings. I haven't been told what the prosecution has used to establish subject matter jurisdiction in relation to this matter. And until that happens, I can't enter a plea. As much as they need me to, I would be more than happy to enter a plea of innocent. But they can't accept that. It has to be guilty or not guilty, because therefore you are understanding the nature and cause to be able to make a plea. And it must be done voluntarily, and in theory you must be fully informed of it. But you never are. Okay. B. Eligibility and criteria free. Yeah. It's just all about eligibility to come in and see them. And that was yours sincerely, Robert. I won't say his last name. And I responded to Robert just quickly there. Hello again. Apologies. I showed him the promo to part 6, not the actual 33 or whatever minute long the promo is, or whatever the full clip is of part 6. So I just corrected it. I get a response back here shortly afterwards. Dear Mark, thank you for your email of the 3rd of October, which has only just reached me today. This is the 9th of October. I am a volunteer who volunteers several times a month on an intermittent basis. Unfortunately, the senior lawyer who I usually refer your inquiries is not available today, so I cannot provide an in-depth reply to your email. It would probably be best to come into the Community Law Centre and see a duty lawyer regarding your matter. Would it? Doing so would result in you having more timely and direct contact. Our lawyers work Monday to Friday, and let's not forget, in doing so, first thing you have to do is fill out a big application form so they can get some money out of you. Secondly, they get you to sign a statutory declaration that everything you're talking about is true and correct under the Declaration or Oaths Act 1957, I think it is, which again, you don't understand, you never wrote it, you don't comprehend it. Yeah. And 2, you having a dedicated file to which the assigned lawyer could refer to. All sounds good, doesn't it? With regards to recording in courtrooms, there is some written guidance in court media coverage guidelines 2016 available at Courts of New Zealand, blah 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 blah. at part 5, notes and electronic records and communications, which states at clause 1, no one other than members of the media may make a record in court. Well, see, now that goes against what the Auckland District Court staff said when they said that I'm welcome to take notes. Reason being is that I'm not there as the fucking media. I'm there as a party to the proceedings. I'm there as a defendant and also witness. So therefore, I have a right to keep record. Where are we? Whether that record be in the form of notes or film or recording unless given permission by the judge. So I can't even take written notes now according to this shit. This is based on the notion that a judge is the master of his or her court, above which there is a recent article from the civil rights perspective available at civiljusticewatch.blog, and he sends me that as well. I respond back with this. Hi Robert, thank you for your reply. During the school holidays I'm busy with the family, but however I shall endeavour to call in within the next week. Within the correspondence so far with Auckland District Court staff, they have stated I can keep notes and that recording could be discussed. This was in response to myself giving lawful notice I would be exercising my rights to do so. I am finding that no one seems to answer my fundamental questions. 1. Does the New Zealand Bill of Rights Act 1990 apply within the courtroom, namely section 14? 2. How is it I must ask permission to exercise a pre-existing right or freedom? 3. Does the court guidelines overrule legislation? 4. As far as I'm aware, the courtroom is a public place. Is this correct? 5. For another to have jurisdiction/authority over myself, this would require evidence. Are we not all equal? 6. While acting within a public office as a servant, where does the judge derive authority over myself? 7. At no time I have stated I am media. I do not do this for commercial gain or revenue. I would not lower my standing to such. I am not a member of any media organisation and may or not publish my personal record. As I wish to exercise my pre-existing freedom to seek, receive and impart information and opinions of any kind in any form, why will I replace this with applying for permission? As I do not accept coercion, threats or intimidation as a basis to comply, what legislation gives the court authority to infringe upon these pre-existing freedoms and rights? These are some of the many questions I have, Robert. See you soon, me. And no, this is the in-court media guidelines they sent me. I would point out application of guidelines, section 1B, do not have legislative force. So these are guidelines. They have absolutely no force and effect whatsoever, and all they do is refer to media, members of media under certain sections of certain laws or certain legislations, none of which I fit into. So good of them to do that. And that was from Stephen. Now I reply to Stephen on the 11th of October, that was on the 10th. Hi Stephen, thank you for your response, and I'd like to point out that he responded to my answers. This is his response here, where he says please refer to the attached document. Please see the attached Word document with the answers to your most recent questions. Alright, and then I got this 2-page thing here called Sovereign Citizen. Alright, don't know if you guys know what a sovereign citizen is, but I've never claimed to be one. Hello Mark, please see the following questions you asked and my answers. 1. Does the New Zealand Bill of Rights Act apply within a courtroom? The answer is the New Zealand Bill of Rights applies to every natural and legal person in New Zealand in their interactions with judicial bodies, including within a court. Good to know then. 2. How is it I must ask permission to exercise a pre-existing right or freedom? His answer: it is not that you are asking permission to exercise a pre-existing right or freedom. There is no right to record and broadcast proceedings within the freedom of expression in the New Zealand Bill of Rights Act. You are able to attend court and have the judge impart information to you. Okay? He's even using the correct words. So the judge is imparting information, so therefore I would be receiving that information. Your right to freedom of expression not infringed by preventing you from recording. Incorrect. You're preventing me from receiving information and opinions in any form, i.e. recording it digitally. The right and freedom does not mean the right to facilitate the placement of your views on a platform such as YouTube, which is your incorrect belief. I'm not using belief, I'm using facts. That's why I supplied them, such as the Bill of Rights Act, Section 14. The right speaks to the ability of speech, not specific styles of speech. He's got a real hard point of trying to grasp what any form and what any kind means. But I'll continue. Number 3, my question. Does court guidelines overrule legislation? Answer: guidelines do not, strictly speaking, have legislative force. No, well, they don't, according to Section 1B of the guidelines. But they do operate by the order of the respective court. As the prevention of the recordings being made without judicial permission, it is therefore a court order. I've never received a court order telling me not to record in court. Never. Failure to obey may result in being held in contempt of court or facing other serious consequences. There is no legislation that conflicts with these guidelines. And incorrect. Bill of Rights Act 1990 Section 14 apparently does, because these guidelines say that you can't take written notes, i.e. you can't receive the information in that public place. So they completely conflict with it, and they do not breach rights under legislation as related in the answer above. Want to bet? 4. As far as I am aware, a courtroom is a public place. Is that correct? His answer: a courtroom is a hybrid of a public/private place, but it is strictly governed by the authority of the judicial officer presiding. A judicial officer has the authority necessary to control the proceedings of their courtroom and administer the laws of New Zealand. Really? 5. For another to have jurisdiction over myself, this would require evidence. Are we not all equal? His answer to this one is: the jurisdiction of a court is only constrained by certain things. Within the sovereign nation of New Zealand, a court will possess jurisdiction over any person in order to administer the laws of New Zealand. The courts are empowered by the Parliament of New Zealand, which is lawfully constituted governing body of New Zealand, able to pass what laws it sees fit and controlled only by the ballot box. Think about that for a second. Only controlled by the ballot box. So if you aren't registered to vote, you haven't consented to be governed. I'll move on. As to whether the state has authority over those who dwell within its borders, this is purely academic. No, I'm talking about facts. Nothing academic about it. I'm being very, very particular and articulated in my wording, and I'm asking a pretty straightforward fucking question. Just because I'm standing here doesn't necessarily mean I've signed up to the laws applying to me. I didn't sign up for it, don't apply. A state is a state if it is able to exert the coercive powers of a state and possesses a monopoly on the use of force within the geographical limit it claims. The New Zealand government clearly can, and therefore is a state, and therefore can exert its authority over you. Bah. Alright, so for all the yous out there, New Zealand government's your daddy. Question 6. While acting within the public office as a servant, where does the judge derive authority over me? Answer. See answer to question 5. Please see the Senior Courts Act for detailed statutory authority. Parliament empowers judges to administer the laws of New Zealand. Judges have the requisite authority over people. Over people now, is it? I thought it was legal and natural persons. Required to administer the laws of New Zealand. You mean the legislative acts given the force of law from consent of the governed. 7. At no time have I stated I am a member of the media. I do not do this for commercial gain or revenue, and I would not lower my standing in such a way. His response to that was, there is a presumption that the media may, in certain cases, record court proceedings without judicial proceedings. That you are not a member of the media means you do not have this presumption available to you. Stop fucking presuming. How about providing some facts? That's all I'm asking for. You might live in a dreamy dream world where you're living by presumption, assumption and belief. I don't. The guidelines under section 1B have no legislative force and have no relevance to me, I state. His response to that was, the guidelines of the courts have force imparted to them by an order of the court. They possess the legal authority and any other order of the court. They are legally binding, really, on penalty of judicial contempt. They are certainly highly relevant to you, and I would advise following them. Really. So when the lemmings is jumping off the cliff, you would advise just keeping in line. I am not a member of any media organisation and may or may not publish my personal record. As I wish to exercise my pre-existing freedoms to seek and receive information and opinions of any kind in any form, why would I replace this with applying for permission? And, quote, as I do not accept coercion and threats or intimidation as a basis to comply, what legislation gives the courts authority to infringe upon these pre-existing freedoms and rights? His answer, fundamentally, recording and broadcast does not fall into freedoms of expression. Are you shitting me? It speaks to platform and nature, rather than the actual ability. If you have the right to free expression, you do not have the right to record and broadcast. There is no such right to record court proceedings, and there is no right to broadcast any such recordings. Well, shit, how are all these people getting away with posting whatever they like on YouTube? It's not freedom of expression, is it? That's not a right. The court definitely has the authority to restrict recordings of proceedings. Further, kind regards, Stephen, and I'm not even going to say his last name, volunteer law student. So that's the opinions of the volunteer law student, trying to scare and intimidate me through scary sounding language, whereas the first senior law guy that responded to me basically confirmed all of my questions. My response to Stephen goes as such. Hi Stephen, thank you for your response, named Sovereign Citizen. Catchy title, however cute, I am not a sovereign citizen. Evidence of registration of an elector or voter would be required to class myself as a citizen. I am an autonomous man. It is a pity man cannot be defined legally, hence why one must use such words as person or citizen or even you. The other definitions are just capacities a man or woman can represent as. I shall pop in later today for further clarification. It would be presumptive to suggest I would publish something just because I wish to record it. Expressing opinions and information of any kind in any form does not limit how I wish, should I choose, how I can impart such information and opinions. As the right and freedom exist and is expressed within legislation, I will use it as I see fit, without any further permission to be sought. I did not state I would be asking permission to express these rights and freedoms. This is not required. I asked how is it I must request permission to use these rights in a public place. The act of applying begging for such replaces that which I already have and will use. Why downgrade? Stephen, you seem to presume anything I record will be automatically broadcast and posted. YouTube has its policy governing privacy and copyright. If I wish to broadcast anything, I am bound by these. However, to record does not mean it will be posted, and as we are a party to these proceedings, we will keep record of it. Love the failure to obey comment, as I do as I wish, and have no obligation to obey another equal or lesser, such as public servants. I'm curious if the sovereign citizen title was a vague attempt to insult me. Those sovereigns have a bad rap. It seems to be extremely simple to me. If one believes one is a you, or a citizen, or a person, comply, obey, expect force and coercion. The state, as you put it, is a fictional entity, and it has no authority over myself, a man. Should I jump into the capacity created by them, it may be possible, but at all times I am a man. Does this not make sense to you, Stephen? As for the courtroom being a private/public place, how so? Perhaps a public building being hired out for private business would be more precise, yes? How tyrannical the staff choose to behave when I re-attend on November the 7th is entirely up to them. All will be recorded either way. Oh, and it may or may not even be published. Judging by the comments thus far from the general public who have viewed this series, all are disgusted with Timmy's actions. One might use nothing to fear, nothing to hide as an analogy. You stated there is no right to record or broadcast proceedings. Why are they recording me then? If a judge gives an order, how do I charge for completing said order? I do not obey or comply for free, do you? ADC has been supplied my fee schedule. Anything they can do, I shall do also. They record me, I record them. Quite simple, really. You seem in error, as recording is most certainly a form of receiving information and opinions, and publishing or posting is, last I checked, a form of imparting information and opinions. I think you may have some fundamentals out of whack, no offence. Evidence of jurisdiction or authority would require evidence. I have seen none and do not wish to assume some fictional entity such as court has any over me. The only thing courts have, in my humble opinion, is the monopoly on using force, coercion, threats and intimidation against those that consent to it. I do not. It would appear most like to put things into classifications, as to have some kind of pecking order. State equals boss or master. Citizen equals voluntary servant under force and coercion due to indoctrination. Put simply, it is the difference between living in New Zealand or on Earth. I choose the latter. I do not use presumption or assumption to govern my actions. I use fact, logic and reasoning, which is why a system running on an assumption and presumption such as the judicial system and I are not compatible, or incompatible. Still, if going to play at court, best know the game being played. Although, Stephen, I can appreciate your first duty is to the court, I can comprehend why you have stated what you have. You do understand that any kind and any form within Bora 1990 section 14 means that I can record and I can post. Legislation is created to govern, control and restrict. Law is created to protect. Both are man-made. My creations do not govern me. To be clear, should I jump into my person suit, that while representing as such, that we do have the right to keep record of these proceedings as a party to them. You say I do not have the right to record this. You are in error. Be seeing you real soon. Love to clarify what you have stated. I may, just as a side note, publish this correspondence, which fits into any kind online also, which fits into any form should this happen. You may or may not redress this with YouTube or another forum I choose to use. Warm regards, me. And I've got no response from Stephen since. After sending that, oh yes, ladies and gentlemen, that very day I wandered on in to the Waitemata Law Centre. That's coming up in part 3. I hope you enjoy. But bear in mind, they told me to come in so I could get a case file. They told me to come in for clarification. You will be shocked to see how this lawyer fails to answer any of my questions whatsoever. He just sits there and nods his head. He knows I know what the answers are, and he completely plays into my hand the way he does it. Good on you, Christian. Anyway, that's part 3. Until later, gotta go pick up my kitties. See you later. Bye.
Good luck.